Okay, and I was just given the message in the chat room that everybody is on, that our public is logged in. This is a something new for all of us. We've never done a virtual conference, fortunately. So hopefully this goes well. I want to apologize to anyone really wanting to do this live. There was quite a few that had that strong desire. Unfortunately, the numbers are just not there to do a live session. We have over 250 people listening to us, and this is strange as hell. Me sitting there looking at a computer screen talking, but could be worse. It could be the presenter doing this. Let's get right to that then. Actually, no, before I get to that, I have to thank our conference committee for putting together such a great agenda. Without the live networking component, we better have good sessions, good subject matter, which we do. So I especially want to thank Mike Martin for chairing the conference committee and putting up with me during this process. I think this is going to go very well. Throughout the session, for each of the sessions, somebody from Gfoa will be in the background. If you have any questions, everybody's muted. There's a Q&A button at the bottom. Please use the Q&A button, not the chat. And we will monitor that, and time permitting, we'll answer questions at the end of each session. Each session is 50 minutes long. We will try our best not to go beyond that because we do have a hard cutoff with the next session being digital links with different links. So our first speaker, it's a pleasure for me to introduce Lee Solomon, a justice on the New Jersey State Supreme Court. I've known Lee for a while. We go back now, we have a lawyer talking to us finance people. I go back with Lee to when we were kids, 20-somethings. And I was the auditor in Haddon Heights. Lee was the councilman in charge of finance. And I remember going in there to support the budget on that budget hearing night, and was amazed that Lee was able to handle all of the questions. And I sat there and did nothing. But it was, it was a good experience. Lee has a hell of a background. I'll just real briefly, I mean, he's been involved borough council, county freeholder, state assembly, county prosecutor. I'm going to miss a couple. U.S. District Attorney, assistant to Chris Christie, prosecuting criminal stuff. President of the BPU, and now State Supreme Court. So it's really great that we're able to have Lee kick off our conference this year, and no better person to talk about ethics in government. So I will turn it over to Lee. Thank you very much. Thank you, Lee.
Thank you, Jerry. And yeah, this is unusual, but I'm getting used to it because right now our courts are operating virtually in almost all respects. And Jerry did talk a little bit about our history together, but I have to correct him on one thing. It's been well over 30 years that I've known Jerry. I was a councilman and also a private practicing attorney in my former life. And Jerry was our finance person. And I can assure you that I didn't answer all the questions. Frankly, I didn't answer most of the questions. Jerry did. So it's a long relationship. I've known him a long time, so long that back then I did look younger and I did have hair. Life has been kinder to Jerry than it has been to me, but just the nature of the business. And I want to tell you that in my position, because I'm a Supreme Court justice, and even earlier when I was just a trial judge, I'm not allowed to give advice, legal advice. I can answer questions based on decisions that we've made. But if anything I tell you is construed to be, you get into a situation and you say, well, I was relying on what the Chief Justice, I just promoted myself again, and the Chief would not be happy. I rely on what the Justice told me. My answer will be, I didn't tell him that. And I'll be very credible when I say it. So please don't catch me on this. And the reason is because ethically, I'm not permitted. I mean, when we're on the court, things that come to us, we have to decide based on the facts and law presented to us. Every case is different. Every ethics case is different. Every legal case is different. And they have different facts, different law, and we have to apply them without any preconceived notions, without any preconceived opinions about the issues before us. So I can't give you advice about what will happen if something came before our court. But I will tell you a couple of things. A lot of it has to do with personal experience. And I'll say a lot of things that I believe in as a person, not specifically as a lawyer or a judge. We've all been brought up a certain way, and hopefully we've been brought up the right way. And we all have certain values instilled in us, and we learn through life about the impact of things we do. We do them right, we do them wrong, we learn of the impact. I, for one, have been always feeling guilty for everything I thought I did wrong, whether ethics ever, typically ethics did not involve, were not involved in the issue. It was simply, I felt I didn't do the right thing in the end. It didn't turn out right. I did it for the wrong reasons. In the end, people are in trouble or out of trouble based on what their instincts tell them. If your gut tells you, because of the values that have been instilled in you through life, that it's just not right, it just doesn't seem right, then you don't do it. If you have counsel, which I know your association does, and I know the municipalities do, and I know every branch of government and every company does, you consult with ethics counsel when you have a doubt. But if it truly causes you concern, you don't do it. I will never forget the advice I got from the first lawyer I ever worked for. He was the best trial lawyer I ever met, and he represented a lot of lawyers in front of disciplinary boards. And often what happened was they got involved in a scheme or a practice that was ethically challenged, whether they had runners to find cases for them, who they paid to bring them cases, or whatever. And I still remember him telling me, and this is a good rule to remember, to never put your ticket in somebody else's pocket. When you do something in front of somebody else or that somebody else is involved in, and it causes questions about your conduct, you have done that. You've given them a basis to challenge you, and you've given them a basis, frankly, to control the license you depend on for a livelihood and your future. Just don't do it. It's never worth it. There may be a short-term loss to you for standing up and doing the right thing, but the long-term gain is infinite. And sometimes those short-term losses, I can speak from personal experience, feel severe, and you worry whether you'll ever recover. Trust me, if you step over the line because you didn't follow your instincts, follow your gut, and follow what you perceive to be the rules of ethics and proper conduct, you'll forever pay that price. And sometimes that price is very high. Only people without that inner guide typically get into that kind of trouble over those kinds of events, typically put their ticket in somebody else's pocket. So I encourage you not to do that. You try to do the right thing. You do the right thing because your gut and your conscience tells you it's the right thing. And most of what I just told you, frankly, is set forth in your own conflict of interest policy. It talks in very general terms about what's the right thing to do. It talks about who's an interested person. Any one of you would be an interested people working for a governing body. And you're not just covered by your own internal ethics, you're covered by statutory requirements of ethics. They're very general, and I encourage you to review them when you get a chance. It is a specific conflict of interest policy, and it reflects in many respects exactly what our local finance, local municipal officials, the laws governing them. It's a New Jersey statute 48:9-22, the local government ethics law. And it sets out some very basic precepts. And by the way, legislators are affected by these issues every single day. But those basic precepts are the things you live by every day. They're ingrained in statute. It's the law of the land. And it's guiding you about things that I'm hoping your inner compass tells you to be guided by. Public trust. Public officials are a public trust. So when you make a decision, it may not be what your local governing body wants to hear. It may not be, frankly, what the public wants to hear. I had to make a lot of decisions, whether I was prosecutor or judge, lawyer, that were unpopular. And I even went, more than once, had crowds come to my place of employment to challenge me on decisions I was about to make or had made. And I had to explain them and justify them in ethics terms, in legal terms, in the terms of I took an oath to do a job, and my obligation is to fulfill that oath, not fulfill people's expectations of me. And I take that very seriously, and you should as well. And I can tell you, I've lived through that from personal experience, and I've had people tell me, well, that's the end of you. And the truth is, in the short term, it may have been, but in the long term, it never was. And I always benefited from trying to do the right thing in the long run. Short-term loss, long-term gain versus short-term gain, long-term loss. I wish there were a lot of public officials out there who heard that back when they made bad decisions. So it's a public trust, and you have an obligation to conduct yourself in a certain way. Our municipal local government ethics law talks about whenever the public perceives a conflict. And we deal with that in the judiciary and as members of the legal profession all the time. People's confidence in us depends upon their belief that we're not acting in our own self-interest or the interests of our friend and family. So perception is everything. And you have to be able to put yourselves, because we're still members of the public. We still go to the store, go to the gas station, go to work, buy things, sell things. We do things that every member of the public does. When we see a public official conduct themselves in a way we don't approve of, it impacts our judgment, our view of them. For you who are acting in their interest, for those who are chosen or elected to act in the public interest, that is very damaging. It undermines the confidence the public has every right to have in their public officials. And it goes on to say governments have the duty both to provide their citizens with standards by which they may determine whether public duties are being fully performed. That is the public's not just perception of you, but the reality of you, and to apprise their officers and employees of the behavior which is expected of them while conducting their public duties. So again, you know how you perceive of officials who don't act in the public interest, but act in personal interest, regardless of the nature of that interest, or in the interest of friends and family. And that simply cannot enter into it. And that's unfortunate in one sense and fortunate in another. It's unfortunate because in our family life and our business life, we're typically acting in the interests of those people. But in the public life, you're acting in the interests of the public. And the interests of yourself, your family, and your friends are subordinated to that public interest. Remember that. The short title, Local Government Ethics Law, talks about a number of different statutory requirements. And in general terms, again, it talks about a statutory code of ethics covering the officers and employees of most local governments and their agencies. You're employees of local government. You may not be full-time employees of local government, you may be, but you're employees of local government and you have these obligations. An interest, and this is reflected in your own bylaws, an interest, and we talk about it in legal terms, which you understand, is an ownership or controlling interest exceeding 10% in a business which is in substantial conflict with the proper discharge of duties of the officer employee. For example, if you are reviewing bids on contracts and you have an ownership interest in one of the applicants, you're disqualified. Frankly, that should never happen. You have to be careful about the interests that you involve yourself in when you seek to hold a public position. But also look carefully at family and close personal friends. But typically family is of most greatest concern because their financial or other benefit inures to your benefit, directly or indirectly. So be very careful of that. No independent local authority shall, for 1 year after the termination of your employment, award any no-bid contract to their employment, the former member, represent or appear or negotiate on behalf of that former member. So when you're looking at applicants, they respond to an RFP, and it turns out your mayor recently got involved with that applicant. Make sure that they're not violating the specific requirements of our local government ethics law. And there are a couple of fairly recent cases, one in which, in fact, I dissented, and I'll explain that why in a minute. There are a couple of recent cases that talk about what that interest can be in more general terms, but be careful of that. Look for those instances. And fortunately or unfortunately, there are cases out there where a public official leaves his office to take over a private enterprise who then becomes engaged with the public entity. And I don't think the public would look kindly on that. And I think you have to be very careful about overseeing a process by which that person has not complied with every aspect of the local government ethics law. And I'll give you that site again. It's New Jersey Statutes 48:9-22, and there's a number 22.1, 22.2, etc. So take a careful look at those. They're very important. You cannot use your office to secure unwarranted privilege or advantages for yourself or others. Again, the others they're talking about are people that you have a relationship with, a close personal relationship, a family relationship with, something that is going to benefit you tangibly and sometimes even intangibly. You can't use your office to secure that. Politics is a tough business. I was in it for a lot of years. I was a private practicing attorney. I was a politician. I am a recovering politician for 20 plus years now, 30 years. And I did the other side of things. I was a prosecutor for a number of years, and then back to public official and then to judge. There's a lot of pressure on you. And there's a lot of people out there that benefit greatly from government. Government contracts, government associations. Every lobbyist in the world benefits from their relationship in government. Puts tremendous pressure on those local officials. And sometimes that pressure is succumbed to. No good ever comes of that. And you are there, frankly, to protect yourself and protect them from getting into that bind, from seeing it as objectively as a human being can see it and understanding what is a real interest. Do they stand to benefit? Had they complied with the law? And by the way, you have solicitors that review that and attorneys that review that all the time. Don't rely on your own legal conclusion, but you can rely on theirs. And when doubtful of their own interest in a situation, seek outside help. Unwarranted privileges is how most people get into trouble. They get a benefit from what they do, and if that is the reason they acted as they acted, it is probably illegal, but certainly unethical. No local government officer or employee shall act in an official capacity in any manner where the officer or employee, a member of his or her immediate family, or a business organization in which he or she has an interest, has direct or indirect financial or personal involvement that might reasonably expected to impair the objectivity or independence of judgment. I'll give you one example that we all deal with up here. If I was a member of a firm, which I was not, I was a sole practitioner for many years after I left the small litigation firm where I worked for that person. His name was Tom Rutter, who I greatly respected and who really provided me with what I think was a good ethical compass. So I didn't work for a firm, but if you recently worked for a firm, or you have a family member like your son, your daughter, your wife, your husband, who works for a firm, and they are involved, and I'm up on the bench and I am involved in a case where their firm is representing one of the clients. if I recuse from that case. I've recused from cases and put on my conflicts list. First of all, every lawyer I ever sought legal advice from, every lawyer who's a close personal friend, if he or his firm argues in front of us, I recuse. Now, fortunately, I don't have a lot of friends, so I'm not recused from a lot of cases. I only worked for one or was associated with a couple of firms as of counsel in the past. So I don't have a lot of conflicts in that respect. But some of our justices and judges do. And in those circumstances, we have to recuse because we have at least a personal interest, if not an indirect financial interest. If we were working for the firm in a relatively recent past, within a few years, we may have a financial interest because we may be still getting revenue that was generated by clients that we brought in. So they recuse. And I would encourage you to stick steadfastly to that general rule of thumb that if you have an interest, a close personal friend has an interest, a family member has an interest, stay away from that. Get advice about that and encourage your officials to do the same. Without, I'm not going to go through each and every one, but they really set the rules and guides. The statute sets the rules and guides that we all should live by on our own. It's improper to solicit or accept any benefit based upon an understanding that the receipt of that benefit shall influence the discharge of any official's duties. You've heard a lot in cases out of our US Supreme Court about a quid pro quo. It's the lobbyist goes to a legislator, hands him an envelope of cash and says, make sure you vote that way. Puts the cash in his pocket, maybe it's a diamond ring for his wife, whatever, and he votes that way. That's obviously wrong. But things happen in a murkier area that just don't feel right. Don't feel right, you just don't do it. And some of the attenuated relationships that we've decided are conflicts for local officials should get you to stand up and take notice. I don't agree with all those findings. I may have dissented from one or two, but that's the law of the land. Actually, I didn't dissent on the merits. These were all, I'll go into that in a minute. I won't talk about it in too much length because I can't tell if you're all falling asleep out there already. I'm hoping you're not, but usually when I talk this long, people are. So I'll try to back off. Views are allowed to be used, his or her public office or employment or any information not generally available to members of the public to secure financial gain to himself or herself. Insider trading is illegal. Similarly, acting based on internal non-public information to benefit yourself financially is improper. It's unethical. And your gut ought to tell you that's wrong. Now, it's not your friend telling you that I just bought IBM. I don't know if that's a good investment or bad. I just bought Exxon. Apparently, that's a bad investment. And you buy it, and it goes up. Is that a problem? No. Your broker tells you to do it. Is that a problem? No. But if somebody in the municipality who is an officer in a corporation that is publicly traded tells you something the public can't get, that might be a problem. So be careful. I think you all know that. Be careful. Seek out counsel. Dot all your I's and cross all your T's. But come back to my first rule. If it doesn't feel right, you just don't do it. The short-term gain's never worth the long-term hurt. Do not represent a person or party other than the local government in connection with any cause, proceeding, or application or other matter before the agency or the local government that you are working with. And that makes perfect sense. You can't represent two masters. That's common sense. So come back to rule number one. Use common sense. It doesn't feel right, don't do it. I'll tell you about a couple of cases, and I'll try to tell them quickly, that I actually was around for. I have only been on the court about 6.5 years. I was a judge before that for a number of years and interrupted by 2 years as president of the Board of Public Utilities. But there was one called Grabowski versus the Township of Montclair. And this gives you a sense of what is or is not an interest and how sometimes it may seem attenuated, but maybe it's not, and maybe it's something you should shy away from. In this particular case, a property owner filed a complaint challenging a township ordinance that permitted the construction of an assisted living facility. And the nothing wrong with that, but the assisted living, as you all know, if you own property within 200 feet, you can challenge that. You can challenge violation of law, you can challenge the merits of the ordinance, the legality of the ordinance. Well, this individual was challenging the ordinance that would have allowed construction of this assisted living facility. There was a church essentially next door, certainly within 200 feet of this proposed assisted living facility. And two members of the board, one was a mayor, one was a council member, were members of that church. And in fact, at one time or another, perhaps when the ordinance was passed and they voted on it, or they were going to approve or disapprove of the allowance, the amendment, they were officers in that church. When the mayor or councilman at one point said, gee, I'd love to put my mother there, good place for her, probably impertinent, certainly raised the public's ire, certainly raised this individual, the one challenging the ordinance, raised his ire, and he raised that to us. We didn't find that that comment was anything more than an offhanded remark, and you know, it would be one thing if he got a preference, but the fact that he thought it would be a suitable place for his mother probably did not present a conflict to us under the statutes. On the other hand, we didn't know what position and what authority these council members had in the church of which they were members, longtime members, and at one point had leadership positions. So we held that the governing body members holding leadership positions in the church within 200 feet, meaning they were deemed to have an interest in, under our law, under our land use law, deemed to have an interest in this permission, this ordinance, would be ineligible to participate in deliberations due to a conflict of interest. So it was sent back to the lower courts to determine what exactly their interest and position was in the church. If they were ordinary members, probably didn't make a difference. But if they were in positions of authority, controlling positions that were different than, listen, I belong to a synagogue, you belong to a church, a mosque, that's one thing. But you have the ability to control the positions, legal positions of that entity that would have had a right to contest or support. That might create a conflict. It certainly didn't look good, wouldn't look good. So we sent it back to decide what their position was. And if they were in leadership positions, they would have a conflict of interest. Now you might say, well, that's kind of attenuated because anybody in that church could object, not necessarily. The church could object as a resident within 200 feet. But just because you're a member of the church, you might not have a legal interest enabling you to challenge the zoning board's action. So that was one. We had another one that I dissented in part on because one of the things about our municipal ethics law is that it does recognize, and when you look at the legislative history, where I was a councilman and Jerry was working with us and lived, I think at the time, in Haddon Heights, it's a small town. It's a couple square miles, about 10,000 people, and a limited number of individuals want to volunteer for services which use a lot of time and typically pay zero. I mean, I remember I was a solicitor to the planning board before I was a councilman. And at the time I was solicitor, we were reviewing the historic district ordinance. And that ordinance was hotly contested. And I was in the middle of a number of conflicts. And we had meetings that went, I don't think, now they end by midnight or 11 o'clock. I forget what the time is that they have to end. But these things ran into the early morning hours. And I made enough money doing that position that I was not eligible for a pension contribution and therefore the state pension. But I still did get paid something. And I figured out at the end of the year or two that I did this, that I made about 20 cents an hour, which didn't seem like a good investment of my time, but that's fine because later I ran for council, which paid $0. Did I run over Jerry already? You're on mute. I'm sorry, you're on mute. I can't hear you.
My bad. When you get a good break, we have to do a polling question once or twice in each session to make sure people are still
awake,
so they get their credits. Yeah, still awake.
I see 22 and 22 people. I'm assuming they're all awake, but go ahead and ask the question, and I'll then discuss the case of Piscatelli versus City of Garfield. And if they're not asleep by now, they'll be asleep after this one.
All right, Angela, do the poll. Is the speaker from the Justice League? Okay, it's not letting me answer, so I hope I get credits for this. All right, back on. Thank you.
Is that a baseball league, football league? Okay, never.
Yeah.
So anyway, in Piscatelli, and this was actually a pretty interesting case, and I descended in part on this because I was talking about smaller towns, limited number of people that will participate, and because of that, there is a potential of overlapping service and the potential for perceived conflict, but the municipal ethics law did not want to discourage people who wanted to get involved, willing to get involved, from participating. And so certain things, some of those situations I thought were permitted to encourage people to participate, where there was not any real, there may be a perceived, but not a real conflict. In any event, the court didn't necessarily agree with that, and that's precedent now. So I'm bound by their opinion, even though I dissented. I now agree with it, and I now would enforce it and go along with it because that's law. It's like when the legislature enacts a statute, and I thought at the time that I didn't like it, I could vote against it and argue against it forever. Can't do that here. But if the legislature passes a law now in my position, and I don't particularly like it, I think as a policy matter, it's a mistake. It doesn't matter. You elected them, not me. They passed the law. I have an oath and an obligation to enforce that law as passed by the legislature and signed by the governor. And it really doesn't matter what I think. It only matters how I interpret that law. So it's precedent now, and that's the way it goes. And in Piscatelli, there were a group of doctors, and they were part of a trust that owned property. And there may have been some individual ownership interests as well. But in any event, they were related to each other. They were in practice, some were in practice with each other. And they sort of varied so that they could construct a gas station, car wash, and quick lube. Not a bad business. Quick lube on 3 separate lots. One of the doctors was a member of the local Board of Education, and in fact was president of the Board of Education for a number of years. 5 members of the zoning board or their immediate relatives were employees of the Board of Education. They did not recuse even though they were asked to recuse. So you have a member and or president of the Board of Education as one of the applicants by virtue of being either a beneficiary or have an interest in a trust or having a personal interest in property. The president of the board, member of the board, ultimately divested himself of the trust and passed it on to other beneficiaries. So he was not a holder for a period of time, but he was still a family member and a doctor and president of the Board of Education. Under the government ethics law and the common law, the potential that a relationship of each zoning board member to the Board of Education could reasonably expected to impact their objectivity and result in a conflict was a decision the court made. that somehow they could feel beholden to or responsible to or be affected by the board member's position as an applicant before them, even though their ownership interest, financial interest may be somewhat attenuated. In addition to which, there was an issue as to whether some of the board members may have been patients of the doctors in their practice. Their patient-client relationships at stake here, so requiring that that be disclosed or discovered affects the doctor-patient relationship and privacy interests and HIPAA, and it's a very delicate situation. So there are a lot of intertwined issues here. The record contained no information regarding the physician-patient relationships of each zoning board member with the applicant doctors, and was limited as to what, if any, authority the planning board, the Board of Education member and or president had over the various members of the zoning board. To what extent could they or would they be affected? So they basically remanded to determine the nature of the patient-doctor relationships involved and the relationships between the employees of the Board of Education and the member who was, or the applicant who was president or member of the Board of Education. And that's understandable. You can kind of get that. I did agree with the majority that the physician-patient relationship is of concern. The majority did conclude, though, that an occasional flu shot, something very peripheral, incidental, is not the kind of relationship we're talking about. But if somebody performed life-saving surgery on the individual, even several years ago, that's of some concern. That creates a relationship that may be of some concern. Sensitive to HIPAA and the nature of the physician-patient relationship, we allowed additional discovery to take place, and I did not disagree with it. But I did believe, and I was joined by Justice Lavecchia, who was formerly a head of the Department of Community Affairs, so she had some experience with this and this law. Because one of the doctor involved, his relationship to the family's trust was too attenuated because he had relinquished his interest in the trust sometime before. I did not think a remand was necessary to determine whether this doctor, in his capacity as president and member of the Board of Education, who could vote on significant matters relating to the employment of zoning board members or their immediate family, should be determined to be a conflict under the municipal ethics law. I thought that was too attenuated. I thought, and Justice Lavecchia thought, that the way that the law is written and the legislative history indicates that they were not trying to foreclose. This was Garfield, I believe. Garfield's a relatively small town. Yeah, it was Garfield, city of Garfield, zoning board of adjustment. It's a relatively small town, and there was going to be overlap. Board of Education members and even presidents might be asked to serve on other boards because they were willing to do this public service. He had done it for decades, and I thought that was not the kind of conflict intended. But at least there is that concern by the court, and I understood the majority's concern, and I understood that Justice Lavecchia and I, as former public officials in a different light, in a different context, had a view that was worth listening to, but is not the majority view, it's not the controlling view, and I'm bound by that majority and controlling view. So you understand how even that kind of incidental relationship or somewhat attenuated relationship can be perceived as a conflict. Now judges are held to a very high standard. And I'm not suggesting that this is a problem for you, but there was a judge, I won't get into the name, he had a close friend who he went to church with. The close friend got into some criminal trouble, I believe was under indictment or had been convicted, and he would still meet him after church for lunch. He'd go to church with him, meet him for lunch. He still hung out with him. And that was seen by a member of the public and perceived by the public, since this judge was a criminal judge, to be a conflict, or at least a perceived conflict. And that is cautioned against, because you have to be attuned to what the public's perception might be. And the law talks about that, and your local your code of ethics for you in your association talks about that. I'm not saying that to say that your license is going to be impaired in some way or that you're going to be impaired in some way, but the public is mindful, particularly in this hypercharged environment, where if you're not with us, you're against us. People will be very sensitive to their perception that there may be a conflict of interest or that maybe you're not acting completely objectively. So be very careful, and when in doubt, just don't. Your code of ethics, like our municipal ethics law, like our government ethics law, talks about integrity and honesty. Act in accordance with your deepest values. It's what I told you at the beginning. It's a circle here. Now we're coming back to the beginning. Your deepest values. You learned these growing up. You've lived these. And if you don't have them, you don't belong in the position. And my suspicion is you all have them and you get acutely what I'm talking about. Doing a job well honors the trust the public has placed in you. You all obviously have a terrific work ethic. I remember how hard Jerry worked for us and all of the finance people that work for us in county, state, government, frankly, the finance people that work in the court system. It's an incredibly difficult job. You're asked to make judgments every minute of every day. So use your best judgment. Treat people fairly. We don't talk about that statutorily, but if you're a good person, you treat people fairly. And I always think of this. I learned this from a person who's very dear to me, who went through some very difficult times in life. And he said the way he does that is he tries to remain humble. He tries never to look, because he's been in a place that was probably farther down than anybody he's ever met, regardless of their walk of life. And he always remembers that. And he treats everybody with a sense of remaining humble and understanding that. And that is the key to fairness. Stay humble. Just because you have a title, a position, you have friends in powerful places. We kind of all are the same in one way or another, and none of us are better than either of us. Embrace diversity and fostering inclusiveness, something that we're very attentive to now, and in light of what's been going on publicly, comes back to fairness. Treat everybody fairly. Apply your own standards, high standards of ethics. And that's kind of where I'd like to end, where I began. If it doesn't feel right, if it's not right in your gut, you don't do it. If there's a concern, you really don't have a sense of it, get advice, get counsel. And I think I'm bumping up against the end, so I'm going to stop there, and Jerry, turn it over to you.
We do have about 5 minutes at best left. It's almost 10:15. I do have one question from the Q&A tab. Hopefully it's, I don't think she's seeking legal opinion, but an old friend of ours from Barrington, Donna Condo, asks.
Donna Condo, oh my God, I haven't seen Donna Condo in, I don't know how long, Jerry. But I know her well, and I remember her days in Barrington. She was a superb clerk.
Yeah, participants are muted, so she can't chime in. But her question is, the police chief retires and immediately goes to work for the uniform company that he directed all purchases to. Is this against the local ethics law?
I'm not allowed to render that opinion. Somebody certainly could challenge it. But I don't know that it would be. That's an interesting question. That's a very interesting question. I don't know that it would be, but I would check.
A lot more facts are needed.
Yeah, well, a lot more facts, but I'm reluctant. If in a quiet moment sitting here by myself, I may look at the books on the wall and answer that question. But those are the kinds of things that come to this court. And there may actually be some local ethics opinions that you can look to that would give you guidance to that. There's nothing specifically in the ethics law that prohibits that. He didn't have an interest. And the question would be, did he benefit in any way from taking that position? personally or professionally while he was police chief? Or did he give them in other words, you really do need a lot of facts, and I wouldn't be able to render that opinion. I don't know that that specific case has ever come before us. It could.
I mean, I could see when I retire, if I went to work for their auditing firm, same thing, or for a computer vendor. I don't, you know.
I don't know that there would be an issue with that.
Right.
That's more a matter of perception.
Right.
The question would be, though, did you do things in your work with the municipality that benefited them in some way? And somebody could raise a question about that. But looking at the question as posed to me, it doesn't jump off the page at me and say that's a problem.
Okay. So we failed miserably with our polling question for the people in the audience. We promise we'll do better next time. There were a lot of people not able to respond. Don't worry about it. If you were logged in, you're going to get credit. Just for next time around, we hope we'll fix whatever the glitch was.
I have complete faith and confidence.
All right. I thank you very much, Lee. Once again, an awesome job. Great presentation. And I forgot to mention, Lee also did this for us back in 2004 for the old people like me who remember that far back. But
where was I working? Was I the prosecutor back then?
I forget.
No, I was the U.S. assistant. I was the deputy U.S. attorney for the Southern Vestiges District of New Jersey.
Yeah, it was Christy.
I tell you, I've loved everything I did. I've done a lot. My wife says I can't hold a job. But I've loved everything I did when I did it. I'm not sure I can go back and do it again. I got old.
Yeah. Yeah. All right. Thank you very much. And I look forward to the next session with all 223 participants. Thank you, Lee.
Gary, you take care. Keep in touch.
Okay, thanks. Bye.
Bye-bye.
And real quick, hi everyone, I'm the host. If you have dialed in on your cell phone, please be sure to email us what phone number you used to dial in and which workshop you dialed in with. That way we can be sure to send out your credits. Otherwise, if you logged in with Zoom, we are tracking who's logged in and you should be good to go. Thank you, everyone.